Hi, and welcome back. Attorney Steve Vondran. Happy Monday, June 4th, 2018. Okay, big case came down today on the courthouse steps of the United States Supreme Court. This is a case I've been talking about. I've been telling you about the cake maker cake, and I told you this one was coming down in June. I didn't expect it so quick, but here it is. So let's get going. Without further ado, let's talk about the cake maker case, or what I call the let them eat cake case. Wasn't there a song when you were a kid, cake maker, bake me a cake, something like that? At any rate, this is what I call a heavyweight battle, First Amendment versus civil rights, okay? And basically, we're talking about the right not to speak, the right not to make a cake, the religious held beliefs, and versus the civil rights and rights of not due process, but equal protection for people. So let's get going. So the Supreme Court let them eat cake case. This case is called Masterpiece Cake Shop Limited and Jack C. Phillips versus Colorado Civil Rights Commission, Charlie Craig and David Mullins. All right, so let's get going. Here's the petitioner's position. This was a case that went up to the United States Supreme Court, and the United States Supreme Court only hears cases when they want to hear it. So it came up on what we call writ of certiorari, and so they agreed to hear the case, usually meaning it's a bigger case that's going to impact the country and the state, and this naturally does. The petitioner's position was Jack Phillips was a cake maker. He was the owner of a cake shop called the Masterpiece Cake Shop, okay, in Lakewood, Colorado. Apparently, he was a very high-end cake maker. I saw some of his cakes online, look really nice. And he named his bakery after Ephesians 2:10, okay, so as a part of the Bible. Under Ephesians 2:10, it says, what we at least have here is the New Living Translation, "For we are all God's masterpiece. He has created us anew in Christ Jesus so we can do the good things he planned for us long ago." So obviously the baker, these appear to be very sincere, religiously held beliefs. That was a big part of the case. And plaintiff's position was that making a cake is an act of free speech. So number one, you're expressing yourself through your artwork or your preparation, and one cannot be compelled to speak. So we've talked about this in my other First Amendment videos. The First Amendment gives you the right of free speech, but also the right not to speak. And so in this case, the cake maker saying, if I don't want to speak, or if I don't want to express my art or make my cakes for somebody, because I don't believe in gay weddings, he's believing he has the right to do it under the First Amendment. All right. Second point, Colorado baker claims that the First Amendment's free speech and religious exercise protections. Remember, under the First Amendment, you also have freedom of expression, but also freedom to freely exercise your religion. And these were the two things that he was claiming were his rights, his constitutional rights. He claimed those rights exempt him from complying with the state law in Colorado, which outlawed discrimination against gay people. And I'll look at that in 1 second. Kristen Wagner, there's the attorney out of Scottsdale, Arizona, defending petitioner. There was, as I mentioned, the Colorado state law, which probably a lot of states have. I don't know if all states have these, but the Colorado state law says no place of public accommodations, such as a hotel, restaurant, or retail store, and such as means maybe there could be others, may deny people the full and equal enjoyment of the goods or services because of disability, race, creed, color, sex, sexual orientation, there you go, marital status, national origin, or ancestry. So there was a state law in Colorado preventing any sort of discrimination along these lines, and apparently he got hooked in under this law and took it all the way up to the United States Supreme Court, disagreeing with it. Frederick Yarger, Solicitor General on behalf of the state, was the respondent. The essential crux of the case was pretty simple. Sorry guys, I don't do cakes for same-sex weddings was the gist of it. I don't believe in it. It's not in my religious beliefs. you can't force me to do something that I don't want to do and actually that I don't actually believe in. So that was the issue. However, it appeared that he would sell what we call off-the-shelf items. So if you came in, needed a box of candles, something like that, or ornaments to put on your cake, yes, he would sell those. But it was the expression of the art that he was opposed to. In this case, the couple apparently, the gay couple that came in, apparently swore at him, flipped him off, and then they filed a complaint with the Colorado Civil Rights Commission under that law. It was held that Jack, the cake maker, has no First Amendment rights. And so that was a big defeat for the cake maker and a big defeat for anybody that would be in his position, an artist or anybody who says, for example, like say you have a very liberal artist and somebody says, you know what, will you make a picture of me and Donald Trump? And they say, no, I hate Trump and I can't exercise, I can't give myself out that way, sorry. You need to go see another artist. It looks like under the First Amendment and under the law of Colorado that may not have been legal. So it's kind of interesting. I kind of ask the question, sometimes I think when you put yourself out in the retail marketplace, it would be nice if everybody that served in the retail marketplace could actually be non-discriminatory. But, I guess these are the things we dream of. But, excuse me. Lower court ruling, Colorado Court of Appeals affirmed the lower court position. Excuse me. There was no First Amendment right as he was not practicing his religion. Sexual orientation is like a protected class, absolutely like race. So in other words, excuse me, in doing the balancing test, the court felt that the protected class being like race was much more important than the cake making, this is my religion kind of thing. So again, he took it up to the United States Supreme Court. As a result of the lower court ruling, the owner stopped making cakes, downsized his employee staff, and apparently free speech rights were chilled. Kind of shut down the cake maker and didn't know what to do, so he stopped. Free exercise of religion outlawed? Maybe. The legal issue to the United States Supreme Court, whether creative artistic professionals, and by the way, this is the way I'm framing the issue, and I may rethink this after I go through it some more, but I just wanted to get this out there. Whether creative artistic professionals have a right to free speech, including the freedom not to speak and or freedom of religion, such that they can refuse to perform expressive services that they believe violates their guaranteed First Amendment rights, speech and religion, notwithstanding application of the Colorado anti-discrimination law. So that's the issue as I frame it. Other people may frame it a different way. Petitioner again argued the compelled speech doctrine. The First Amendment prohibits the government from forcing people to express messages that violate religious convictions. Yet the Civil Rights Commission requires Mr. Phillips to do just that, ordering him to sketch, sculpt, and hand-paint cakes that celebrate a view of marriage in violation of his religious convictions. So you see the fight that's going on here. Respondent's position, this is blatant discrimination, should not be permitted under Colorado's anti-discrimination laws. And here we had David D. Cole, Washington, D.C., I believe was an attorney that was assisting as well. So U.S. Supreme Court holding, let's get into it here. Let's go over here if I can find this case. Let me do this. Let me do that, and let's pull up this. Whoops, not pull up that. Let's pull up this. All right, here's your Supreme Court of the case. This is the decision that came down today. You can find it online. I'll put this link in the video box below so you can go and review it. I'm not going to go over all this. I'm going to go down and kind of look for a holding, something that looks like a holding. Let's see. So here he is. He's been an expert baker for 24 years, a devout Christian. He explained that his main goal in life is to be obedient to Jesus Christ and Christ's teachings in all aspects of life. And one of his religious beliefs is that God's intention for marriage from the beginning of history is that it is and should be the union of one man and another. So that's why he doesn't want to make the cakes. And the court said that's fine. The ruling kind of surprised me. The court said that's fine. And today, what does it say? Today, the Colorado Anti-Discrimination Act carry forward the state's tradition of prohibiting discrimination in places of public accommodation. Let's see here. So, and again, that's the law we talked about, but let me see if I can just find a quick holding here for you. I usually just look for that juicy piece that kind of sums it up. This looks pretty good here. Kind of sums up the crux of the case, and I'll let my Mac do the reading for you.
Our society has come to the recognition that gay persons and gay couples cannot be treated as social outcasts or as inferior in dignity and worth. For that reason, the laws and the Constitution can, and in some instances must, protect them in the exercise of their civil rights. The exercise of their freedom on terms equal to others must be given great weight and respect by the courts. At the same time, the religious and philosophical objections to gay marriage are protected views and in some instances protected forms of expression.
And here's another little clip.
Nevertheless, while those religious and philosophical objections are protected, it is a general rule that such objections do not allow business owners and other actors in the economy and in society to deny protected persons equal access to goods and services under a neutral and generally applicable public accommodations law.
Okay, and so it goes on, and I'll let you read and pull out your favorite rationale out of the case. I don't want to go too long on this video, but the link is down there if you want to read it. I think it's a great case for discussion with your friends. The decision was 7-2. Well, now that was kind of a shocker to me because so many times these Supreme Court cases are 5-4, and 5 justices see it one way, 4 see it the other. But here you had 7-2. And the dissents, I believe, was Sotomayor and Ginsburg were the two dissenting opinions. So there you have it. So I guess by all standards, I guess that's a pretty easy decision as far as the Supreme Court. Do you agree with this opinion, or do you think it creates a weird environment where you can go into a store and ask for something and they can say, hey, I don't believe in your religion, hey, you're a neat guy and everything, but go down the street. I just think that's kind of a weird view of a marketplace, and I think that when you put your goods and your wares out to the public and you're offering up your services, you need to be thinking about these things. But I also understand, a liberal artist wouldn't want to be doing some grandiose picture of Donald Trump with, so you see the problem. But anyway, I hope you like this video. Breaking news. I wanted to be one of the first to bring this to you. But give me some comments if you like it. Let me know your opinion. If you think it's a bad decision, feel free to do it in a nice way. Try to keep our board nice, but feel free to exercise your free speech rights. Okay. Attorney Steve Vondran here. Hope you've enjoyed. We'll see you again. Got to get to work.